Uh, Thank you very much, Giancarlo. In reaction to what Chris said, even though I'm wearing a suit, I'm not a lawyer, I'm a technologist by background. Even though some people believe that I'm a lawyer because I've been following data protection law for more like 40 years in different functions and like 13 years now as a full-time job. And then some people actually thought, but we don't have a real uniform at the EDPS, but I thought I use this cap to indicate that technically I'm a law enforcement officer because it's our task to enforce data protection law, and to have this base cap with the EU logo on it is the best I can get in that respect. But I normally don't wear that for work. So when I come to work, it's more like wearing a suit and no tie to not become too Dilbertish. Okay, I'm talking about, I'll also come back to some of the issues that Chris mentioned, like state of the art and related concepts, but I'm talking about privacy by design, not security by design. I mean, security by design, as we learned, was born in the 1970s already as a concept. Privacy by design, as I will explain, was born in the 90s as a concept. Brief overview of the talk. I go a bit in the background and history, in the context. What is actually the EDPS, the European Data Protection Supervisor? I guess the audience has many non-European members, so I think it might be useful. Then what happened with the GDPR? We go from privacy by design to data protection by design. What happened? What is the difference? I'll have a closer look at GDPR Article 25, which is the one on data protection by design and by default. And then we have the core concept of state of the art, on which I will dwell a little bit. It's not totally different, but also not totally similar to the one in US jurisprudence. And then I have a few questions to the audience, which don't need to be answered immediately today, but will also be happy to get feedback from there. And then I say a few words on what we are doing and what the research community and industry, to the extent that they are participating, can do. So the EDPS is the data protection, the independent data protection authority for the EU, and that means in particular the EU institutions. So the EU is not the United States of Europe, so it's not a federal structure, but it consists of totally sovereign and independent states, and it has a supranational structure with its own institutions and stuff. And by this construction, the EU level itself cannot be subject to supervision or jurisdiction in some aspects of the national authorities, and so there must be supervisory authorities at the EU level. I mean, this is similar. You couldn't have a state supervising federal authorities in the US. That would be a similar difficulty. So that's why there is a European data protection supervisor, in addition to every member state's own data protection supervisory authorities. We have currently 2 elected members of the board. This is an expert assignment, so it's not like party-oriented. Giovanni Buttarelli and Wojciech Wieworowski are in office until 5th of December, and then the new successor will come into office, which is currently still to be elected by the European Commission and the Parliament and the Council of the European Union. The tasks of the EDPS is the supervision of the processing of personal data by the EU institutions. Like, what are they doing? The Commission is giving out some billions of grants every year, and of course in that context it collects data about grant recipients, about the reviewers, the experts that help them select. So there's something, there's some 60,000 staff whose data is processed, and plenty of other actions where the EU directly processes personal data. We are also an advisor as the institution to the legislator. The Parliament is very keen to hear our views, while the Council, the representation of the Member States, knows everything better than everybody, so they are not very keen to receive advice. We also have explicitly the task to monitor technological and other developments which are relevant for data protection and privacy, and of course we cooperate formally and informally with the other data protection authorities within the EU and relevant areas. The GDPR became fully applicable on 25th of May last year. That is Towel Day, for those who are familiar with the Hitchhiker's Guide. And I know that one of the persons involved in negotiating the GDPR is also a big fan of Douglas Adams, so I'm not sure that that was total coincidence. But anyway, so it's easier to remember. And the ancestors of the GDPR are national and regional data protection laws in Europe, which were adopted in the 1970s. We had nationwide laws in Sweden, Germany, and France in 1973, 77, and 78, respectively. And what was common to data protection laws at the time was that they all said, well, the data has to stay here in our jurisdiction because we cannot be sure that they are treated properly anywhere else in the world. And of course, when more and more countries have laws that restrict the exchange of data within companies, for example, within multinational companies, the businesses become interested, and the ministries of economy also become interested in making sure that this doesn't impede trade. So, and already in the 1980s, discussion started about international instruments to find some way to make it easier to transfer data from one country, personal data from one country to the other. And at European level, it was the Council of Europe, which is like an organization of nearly all countries in Europe. This totally distinct from the EU. It has some 45 member states, but includes countries like Russia, Serbia, Albania, Turkey, which are not obviously part of the EU. And this organization could agree on what was then called Convention 108 on the processing of personal data, which has in the meantime been revised over the last couple of years. It's now called Convention 108 Plus, has been modernized to be more aligned with the GDPR. And actually it's open for non-European countries to join. So I think there are some on the pipeline. Argentina, Mexico, Canada are considering it. And of course the US are totally welcome to join this convention. No? But I know that currently they have a bit of problem with international conventions as a concept. But anyway, my colleagues from the COE, they're traveling all the world and inviting countries to join Convention 108. So these are the ancestors, and then we're starting like in the 90s, we got what I would say is a parent generation. We have first of 95, the Data Protection Directive, which was the common instrument for all EU countries until the 25th of May last year, which is accompanied by its younger sister, the e-Privacy Directive, which is known to many people more as the cookie law, because one of the 16 or so articles has one paragraph which relates to the placing of information on a user's device and reading information from the user's device. That is actually the thing which refers to cookies, while all the rest is about confidentiality of communications and related things like what can you do with the location data of the user which you collect Unfortunately, the current draft was designed just after the first digital mobile services and digital telecommunications in the traditional field were made. So it was, when it thinks of location data, then it thinks of location data that is found by the network, so which depends on the cell tower, not on the GPS, which is built into each and every mobile device. And it's also up for a new review. The 2009 review was done, but it's in kind of state of extended pregnancy or hibernation, because the member state governments cannot agree on how much confidentiality they want to grant citizens with respect to their electronic communications. There's signals that might be hope or not, that things get off the rock later this year or over the course of next year. Another sister of the Data Protection Directive was the so-called Framework Decision 2008-977 on Justice and Home Affairs, which is the data protection rules for police and judicial cooperation. And the last one, which I mentioned here, was the regulation which actually establishes the EDPS, which defines the data protection rules for the EU institutions themselves. And the GDPR has a sibling, that is the Law Enforcement Directive, which replaces the framework decision and defines the new rules for data processing in police and judicial cooperation. The instrument which we call the EDPR, the EU Data Protection Regulation, which is the new EDPS regulation, which defines the processing rules for the EU institutions themselves, and the e-privacy regulation, which is forthcoming, as I said. So the point I want to make is that GDPR didn't come from nowhere, but it has based on a tradition which goes back like nearly 50 years, 45 years. And what does it provide in substance? So there was a few things where it provides clarifications on things which were already there, like the definitions of what is actually personal data, what are the different roles in the context of processing personal data. Then there are clarifications on some obligations which already existed. So for example, the idea of consent has been elaborated with a lot more clarity, which means what kind of information do the people need to have before they make a decision. Is it possible to actually have consent conditional for using a service? The answer is legally no. And that is one of the things which is in the process of becoming subject of enforcement and judicial action. And then it will, hopefully, we will see that there's more change. Transparency, there's a lot more information clearly written down to be provided. I would actually say on the consent that the usual privacy policy where it says we value your privacy, we will not share your personal data with anyone, except that we have a legal obligation, or we have good business with the other party, or we find any other reason why we would like to share it, is not up to match the transparency obligations of the GDPR, because its purpose, as we heard also in some SUP's presentation, is to protect the processing entity against all kinds of charges of misleading. But I mean, because it provides no information, it's not really clarifying anything. Another element which is becoming very important is that the GDPR now tries to sort the situation where more than one entity is responsible for the processing. That's the concept of joint controllers. Just a couple of weeks ago, there was a judgment that anybody who involves a third-party tracker, includes a third-party tracker into their website or service, they are at least responsible for the collection and the transfer of the data, and then the actual processing is in the responsibility of the third party. But basically, the two of them are jointly responsible for the operation, and they need to have an agreement which defines where the separation between responsibilities is. So models where a website operator says, yeah, I have Google Analytics, but that's not me, I have nothing to do with it, I cannot be responsible in any way. Or the other side where the third party says, well, you know, I do the processing, but it's up to the website operator to get all the things sorted and proper agreement and proper information for the user. Neither of these two models is going to work any longer, but there must be some structure which takes account of the separate and joint responsibility. And then we had some clarifications on international transfers, which are of course relevant when I'm here from Europe in the US, under which circumstances actually companies can transfer data in between the countries. We have some clarifications on the rights of the data subjects. Data subjects in GDPR speak are those whose data is processed. So one of my bosses uses to open speeches by saying, ladies and gentlemen, dear data subjects. So you all can feel addressed. And there's a very famous talk about something which is called the right to be forgotten, which is considered by many to be something completely new. Well, it's just the right to erasure of data which is not needed, which has existed since the 90s. And there's also some clarification about the tasks and powers of data protection supervisory authorities, and that has, of course, created much of the hype and interest, because that included the clarification on administrative fines, the famous 4% of turnover, 20 million, whatever is more, or in the context, as we will see here, 2%. There's also some material changes and new concepts. The territorial scope of the GDPR has been changed. It's always anybody doing processing within the EU is subject, but now it's made clear anybody who intentionally processes data of people in the EU, regardless of their citizenship, is subject to the GDPR as well, regardless of where they do that on the planet or outside the planet. Accountability has been introduced as a new principle, and that basically means whoever processes personal data has to be able to show that they are compliant. And this includes some principles: data protection impact assessment as an obligation in certain cases, data protection by design, the data protection officer as a general thing, and a few more things like certification also is closely related to accountability. And then there is a whole new effort to ensure that the GDPR is applied more harmoniously than it used to be in the past, where the 28 countries often had very different flavor. And there's more instruments on cooperation, which is peer-to-peer cooperation between authorities, and a strong consistency mechanism with a special body to organize that, the European Data Protection Board, which consists of all of one data protection authority per country, and has even the possibility to take a majority vote on a case which covers more than one country when the authorities cannot find a common ground. And then we have taken on board based on the experience we had in the telecommunications sector, which goes back to what happened in California many years ago with personal data breach notifications as a separate instrument. Okay, data protection principles which are subject to accountability, lawfulness, fairness, and transparency. Purpose limitation: data is collected for a certain purpose and not used for anything incompatible with that. Data minimization: don't collect and process more data than is necessary to achieve your objective. Accuracy: as a data controller, you are responsible to ensure that you don't process data which is outdated or incorrect. You cannot keep it forever. There's a limitation to the storage period. And security of data is here reduced to 2 of the 3 standard elements, because loss of availability is probably considered such a severe restriction for the controller himself or itself that they didn't need to put a legal obligation here, even though there's a more comprehensive model of security later on. I mentioned accountability. I put here security again because it's also its own article, and the rights of data subjects. Lawful processing, this is also just necessary often to repeat. It's not notice and choice or notice and consent or something. Consent is one possible reason for processing, and it has to be for specific purposes. But the other 5 elements are also important. That is, if there is a contract, then data needs to be processed for the completion of the contract. That is covered. So when I go to the travel agency and buy an airline ticket, then the travel agency doesn't need to have my explicit separate consent for telling the airline who will be their passenger. I mean, otherwise they take my money and then they say, without your consent, we cannot buy your ticket. So, I mean, it's necessary for the completion of the contract, and that should be clear. There can be legal obligations. Plenty of them exist, like, for example, just a bank, when it takes a big amount in cash, is obliged to get the identity of the person who's bringing 10,000 or 50,000 euros or dollars in cash, just to avoid money laundering. So they don't need my consent for this because they are legally obliged to do that. The vital interest of the individual, or it could also be another person, is when after a traffic accident I'm unconscious on the street. Of course they have the right to look whether I have a blood group indication or to collect data of me, and so even when I'm not in a position to give any consent, and that's not very often. Then public interest is something which goes beyond the concrete legal obligation as under point C. But important is that for point C and point E, there is a legislative requirement. So the state or any authority cannot just say, oh, it's in the public interest, so we process this data, but there must be some legal base to refer to. And then the last item, that is the most complex one, legitimate interest, which is actually the most used one, because all the web tracking is based on the concept of legitimate interest. That's why they still think they can do it without transparency. Well, the transparency obligation applies anyway, but they don't need to ask for consent and so on. And this is being developed currently more and more by the European Court of Justice. Actually, the definition of legitimate interest, so the balancing between the interests of the controller and the individual, was the most important part of the famous Google Spain judgment, because the Google Spain judgment, which is known for creating the right to be forgotten or giving the interpretation of the right to be forgotten, actually had to distinguish between what is Google's legitimate interest of processing personal data in the context of its provision of the search engine versus where is the right of the person whose data is used in this search process to say, stop it, that's infringing on my personal rights. And in the case of this Spanish dentist, the court found that in this specific case, his interest of not being connected forever and ever to some mishap in his life history was more important than the legitimate interest of Google. Okay, the powers of DPAs are based on all the provisions of the GDPR, which they have to enforce. So we have the right to ask for all information that we want, and actually not just ask kindly, but order it to be provided, also including personal data, which we of course have to process with the proper safeguards. Then we can do certification reviews and audits on site, and we have the right to access premises, so directly from the law. We don't need, as it was in the old thing sometimes, we don't need to go to the court and get a warrant. Like the ICO, when they were investigating Cambridge Analytica, they also, at some point, they seized the servers of Cambridge Analytica. So they went into Cambridge Analytica premises and took the servers, and they are now in the lab of the ICO. But they needed a court warrant, which took several days. And so the provider knew for quite a while that they were going to come, and nobody knows what was happening on the site during these 4 or 5 days that it took. So this is basically should not happen now with the GDPR, because they should be able to access it immediately. And the authorities can instruct controllers to be compliant, issue warnings, but also say, stop this processing operation, change it. And if you want to read the 50 million euro fining decision of the French Data Protection Authority against Google, it's not only an amount which by normal perception probably doesn't make a visible dent into Google's annual result, but it also has instructions on how they may or may not continue processing, which may be much more effective if it is properly implemented. We can also totally stop a processing operation, same as for a data flow, both internal or externally. And when data subjects don't get the data they asked for, subject access requests are not responded to, or any of the other things, or if data breaches are not reported, then the authority can order the also the controllers to do that. And not following an order, of course, is a worse infringement than not doing what they were obliged to in the first place. And then the last resort, of course, are the fines, which get so much interest. So from privacy by design to data protection by design. Privacy by design was in the discussion since '95 in the first papers. It's a high-level framework, would be difficult to enforce. And the GDPR approach is data protection by design and by default. We use the acronym DPBDD. And if you want to be cool and show that you have mathematical or technical background, then you say DPBD square. And then some lawyers already don't understand how there can be a square in an acronym. It's based on the accountability concept and the principles of data protection, because it's one of the obligations by which the controlling entity can show that they have understood and are compliant with the rules. It's a legal obligation, so it's no longer good practice. And violation may be fined up to the higher of 10 million euros or 2% of the turnover. Up to, I mean, that is also often misinterpreted. It's not as if there's any violation automatically goes to the maximum fine, but there's of course a long range of appreciation. And certification may help to achieve compliance and demonstrate that accountability has been taken into account. And of course there need to be appropriate standards against which to certify and certification organizations. Privacy by design, document on the left-hand side is a publication from the Ontario Privacy Commissioner with the 5 principles. Document on the right-hand side is an opinion of the EDPS, which we published last year, where we explored the concept of privacy by design, elaborated a bit on the difference between privacy by design and data protection by design. And basically we call it preliminary opinion because we invite the relevant community to comment on it so that we can develop that and maybe have one day a second generation of this document. So you're all invited to go to our website, find this document, read it, and send comments to us or me personally so that we can integrate this. Serious invitation, so it's not just to say so. The article, as I said, data protection by design and by default. Those elements are, by the way, present in the privacy by design concept earlier already, but here they are separate legal obligations. And basically the by default means if there is a choice to collect more or less data, then you should start with less data and only go more by when the user actively changes the default. Well, that's a long slide with the full text, and it there should be some highlighting, which apparently has somehow disappeared in the reading process. But there's a lot in the first part. There's a lot of factors which are to be taken into account, and it starts with the state of the art. Then there's a reference to cost, the kind of processing, and the risks of varying likelihood and severity. So clearly there is a reference to state-of-the-art risk management, but privacy risk management, not security risk management. And then the controller shall take appropriate measures to implement the data protection principles, which we have seen a few slides before, and to integrate safeguards. And the measures shall be taken both at the time of the determination of the processing means and purposes, that is design phase, as well as at the productive operation. So it's trying to cover the entire life cycle of software operation. One concept which will be very relevant in assessing concrete cases is, of course, the state of the art. In Europe, we have jurisprudence on this in consumer protection law, which is a bit similar maybe to what we have here. We have also in concepts on this in environmental law, where it's just not allowed to pollute more than is technically necessary. And actually, this still needs to develop for data protection, but we have the distinction of different levels of state of the art. So there's the cutting edge, the most advanced. There is that what is commonly considered standard practice by every decent professional in the field, and then there may be areas where this is not yet fully there. And we consider that this is well, in data protection law, we had the term already in the security article, which is basically unchanged since 95. It's a dynamic concept, state of the art now and state of the art in 2 years. It's thanks to all the wonderful researchers which are meeting here, is not the same. There's progress. And but we as the supervisory authorities, and of course also the organizations processing data, we have to have some kind of common understanding what is the state of the art, because we have to be able to tell an organization this was state of the art or this was not. And the two recent fines that Chris already mentioned, the one against British Airways and the Marriott hotel organizations, were quite high, because among other things they really made stupid mistakes in the security area in that case. But I mean, storing sensitive data in unencrypted on a web accessible server, I mean, this is not state of the art. So, and all the cases which were mentioned in other presentations today, where passwords are stored in clear text on servers accessible to a huge number of people, of course, definitely not state of the art. Standardization would help. There are several initiatives ongoing at ISO and other standardization organizations to establish privacy standards. And the GDPR has the ambition also to trigger an advancement of the state of the art in general. And here are 4 questions. It's the questions I announced, questions to the audience, not from the audience. One which could be, I mean, we had Soups and Pepper from Sunday to yesterday, conference on usable privacy and security and on privacy engineering practice and respect. These are, of course, sources to learn where do we stand. And of course, so I think at this hotel these days are the people who can give valuable comments on the first question. I originally said I thought I would put up 3 options, like saying 100% yes, B, it depends, and 3, definitely not. But I mean, everybody would probably go for B anyway, so I'd rather ask, what does it depend on? And that goes with the second question, where are the gaps in the current state of the art? Which fields of privacy, what do we need more? Do we have the concept? Is it just about practice? So people have been talking about layered privacy notices, icons about the processing operations, possibility to have easy, like a nutrition label on a service to decide on whether you want to do it or not. So there are ideas. Are they sufficiently mature? Do we need more research? And I think one area where we, which I learned from Soups in particular, is that the human factor in these interfaces is something which developers need to learn a lot more about, and I'm very glad to see that there is really great research. The role of the public sector, as I said, it's expected that the public sector provides incentives, and the last point is all the obligations of the GDPR apply only to the organizations that actually process the data. So when an organization buys devices like TVs or IoT devices, which are not come without being connected to their manufacturer's services at the time, which is often the case, but imagine it's really like the hardware and the programs in the hardware. These suppliers themselves are not subject to sanctions under the GDPR, only their customers who use that to provide services. And so good ideas to up the incentives for the manufacturers and developers is also very welcome. What are the DPAs doing? Well, we do enforcement. I'll have a slide on that in a minute. We develop guidance, both individually by each DPA and also in the EDPB. There was work ongoing. And of course, we have our own exchanges with other organizations, partly at places like this, but also in specific events and cooperation groups. And of course, we are very interested in cooperation with research. We cannot ourselves participate in research projects due to legal constraints, but everything which is below the level of direct participation, we're very interested in cooperating also with academia and research institutions. On enforcement, there was just about a month ago the first fine, which actually referred to Article 25, data protection by design, by the Romanian Data Protection Authority, which fined a bank for a mistake in their user interface in online banking, I think it was, because Romania is a country where every citizen has a citizen ID, which is probably worse than a social security number in effect when it is stolen. And the program was implemented so that everybody who received a transfer would see the sender's citizen ID in their bank statement, which was totally unnecessary. So you could also argue it was a violation of data minimization. But the bank itself didn't do anything with it other than displaying it. They had to store it because of national banking law, but showing it in the user interface program was definitely a mistake in the design of the software, which shouldn't be there. So the authority decided that a violation of Article 25 was one of the reasons to issue this fine. And there may be more coming forward. We ourselves at the EDPS, we have issued guidelines on several aspects already over the past 4 years on IT governance and management, which is the framework, and specific services and activities. All of this is up for review over the next few, I think until next year sometime, to be fully compliant with our new regulation. We have set up what we call the Internet Privacy Engineering Network, IPEN, where we cooperate with industry, academia, DPAs, and what I forgot to mention here, civil society. It was triggered in 2013 by particular the reaction of the Internet Engineering Task Force community on the weaknesses that were revealed in the technical standards of the Internet. We started in 2014. We have a workshop every year, at least one, and we also had a few special events. The next workshop is in Lisbon in June next year, and we'll probably have 1 or 2 other workshops in between. And of course, industry and researchers are invited. This year in Rome, we talked again, state-of-the-art business models that can work without tracking, privacy engineering methodologies, and anonymization versus pseudonymization. We had 4 conclusions, so there's more privacy engineering than most people think. And that is very interesting, there's more consensus even across borders of legislations. Because on the engineering level, the guidance which is produced by NIST, the National Institute of Standards and Technology in the US, and the guidance that is produced by the technically oriented teams of the data protection authorities in Europe are very, very compatible. And that means from the engineering perspective, even though the legal frameworks are totally different, there is a lot of common ground. That's a very encouraging result. There's many elements where we know what is the right thing to do, but not for all points is as explained at developer level. So when we talk to developers, even in our own supervised institutions, they often say, yeah, I can read your guidance, but I still don't know how to program this. So I need it even more detailed on which library is good to use, which library should I avoid, and all this kind of things. And of course, dissemination training. I think there's hardly any speaker today who hasn't said that there's more need for training and education and also dissemination to practitioners. What we do, that's what we kind of will include in our new manifesto, thinking about new ways of spreading the knowledge, working, this will be really the hard bit, is number 2, to really break this down so that managers and developers in the corporate IT can do that. We need a community to fill the gaps, and so we'll also need to maintain the community. No. And this slide has kind of effect to it. So that's my last regular slide. I think I'm also close to the end of time. So thank you very much for your attention.
Thank you very much, Achim. So, any question? Just give you, we have 4 minutes, so I think 2-3 questions, average short. Yeah, thanks.
Okay, I'm going to preface this with I am not a lawyer. Article 28 of the GDPR lays out the, if I remember correctly, lays out the processor and controller separations of duties. One of the interesting things that I noticed about this is that in practice what that's doing is it's pushing companies to use larger and larger processors and subprocessors because the notification burden is so high and getting people to sign off explicitly on every new processor is, the burden of that is really high, and it makes it a lot easier if you use larger processors. And I don't think that's intended, and I don't know, I'm not saying that this is a bad breakdown, I like a lot of things about it, but there was a lot of, people were talking a lot about, hey, let's make sure we don't burden small business more than large business. And do you have any ways you think you could tweak that to maybe make that not have this push towards larger companies in the marketplace?
Yeah. The short answer is, and I can give you a longer one separate, the short answer is this is very much due to the hype and fear that has been distributed. We think that we find that in countries where data protection has been taken seriously, also small and medium enterprises are fine with maintaining compliance.
I'm not saying that. I'm saying specifically when you're getting processors.
Yes.
Because engaging every additional processor.
Yeah. I think it's a misperception by the organization. That's a short answer. Okay.
Hello, I'm Jeffrey Goldberg, DPO at 1Password. One thing that I've noticed missing in the privacy by design documents is the role of end-to-end encryption using keys that are belong only to the data subject. And I found just in dealing with the regulations that there does not seem to be a recognition of that as both a core of privacy by design, but also really as a possibility.
Yeah, I understand this, but I think this is just it's already difficult enough to get legislator understand what encryption is in the first place, and then going into the difference whether the controller owns the keys or the user owns the keys. That's a step too far for the law, but it's something that we can address in the guidance following it.
Achim and Chris, you both addressed the notion of state-of-the-art and what it means for security requirements. The second kind of like requirement in the text that you showed us is like cost of implementation. And for me, kind of like, I thought I had an idea about what state-of-the-art means, but in conjunction with this cost of implementation, this becomes a very relative concept. And I'm curious if you can help us better understand how we have to understand this notion of cost of implementation.
Good question. Chris has mentioned the concept of cost-benefit analysis, and we tend to interpret the cost argument as something which must be really the costs which are additional to anything that the controller would do for their own interests, and also when better privacy solutions actually improve the business effect of the software, that cannot be taken as the cost of the privacy implementation. So, but indeed that's a complex issue, and the accounting background, of course, is also quite interesting. But we have that in the eye, and anyway, it cannot be like, you cannot store passwords in clear text just by saying, well, I would need a bigger processor to encrypt them before I store them. So that would not be a valid argument even by the cost angle, because then it balances against the damage.
But it somehow makes the concept a little bit more relative, is that right?
Yeah, unfortunately the legislator is very keen on having everything taken into account. So, yeah.
Thank you.
Hi, I'm Calvin Cito with Uber. So I have a question about GDPR as to how would it apply to government agencies? I mean, in the light that there's a high profile breaches, and
Yeah.
like the revenue model and penalty doesn't
Yeah.
really
Yeah.
apply.
Yeah, I mean, we are dealing with government agencies as the EDPS exclusively. We have the power to fine them, but as you say, it doesn't really make much sense because then the state budget goes from one institution to the other institution, and actually it doesn't go to us, but it goes back into the general budget, so nobody earns anything. And the damage would only be secondary because someone who causes his authority to lose budget can be personally be made responsible for losing this budget. So that's a very complex thing. At national level, this may be more different because they're not all on the same budget. And in principle, all authorities which are not police or justice are subject to the GDPR directly. And only for police and justice authorities there's a separate regime, and they are also under supervision of their national supervisory authorities. But member states had the margin to decide what kind of sanctions they allow against the public sector, and they've all taken different flavors, unfortunately. Some have not given the authorities the powers that I listed with respect to public authorities, unfortunately. But they all have some powers. So, okay, thank you.
Okay, let's thanks once more Achim.
Thank you.
And coffee served outside, I guess. Thank you very much.